The last two Supreme Court justices, actually, I mean, when it comes to the last three, I would say honestly, in the better half of the 21st century, when it comes to the process of confirming justices, it has become extremely partisan when it comes to serving for life. Okay, that idea, the sense of an individual serving for life, okay, on the Supreme Court. So again, very indicative of why it becomes very, very controversial, very ideological. It's one of those battles that, again, will serve for an eternity. The idea that somebody will, until they no longer breathe, will serve on the court that, again, decide the direction based on an opinion rendered in cases. So, again, we're going to be talking about what that means, what the Supreme Court specifically does, how they take up cases, what it takes to be on the Supreme Court, but also what it takes to be heard by the Supreme Court. Okay, in the sense of what this chapter is going to talk about. All right. So the last four Supreme Court justices. Okay, so whenever there is a change in the Chief Justice of the Supreme Court, so that means the Chief Justice will die. So our current Chief Justice is John Roberts. Okay, so John Roberts is our Chief Justice. Before him was William Rehnquist. Okay. So again, you're going in backwards order from where we're at now. So the Supreme Court justice is always put on by the president. Okay, so whenever a Supreme Court justice dies, the president during that time period gets to choose a replacement. Right? A Supreme Court justice is supposed to be neutral in the sense of what they are, who they are, and interpretation of the law. Because again, that's what the branch does. It interprets the law. Okay, so again, the judiciary is interpreting our laws based on, again, circumstance and very much uniqueness of a case. Also draws in why a Supreme Court would take up a case. So when you're talking about the different types of courts, so one can have an angle of having more of a progressive activist judge, or they could have a conservative restraintive approach to interpreting the law. Okay, so what do I mean by that? I'm going to show you guys in the next slide. Okay, so I'm going to show everyone. So William Rehnquist was the Supreme Court Justice, Chief Justice before John Roberts, our current one. Before that was Warren Burger. Okay, Warren Burger, also known as a conservative restraintive court. Before him was Earl Warren. Okay, Earl Warren was known as an activist court. Okay, so activist in the sense that the Supreme Court during that time passed the Civil Rights Act, the Voting Rights Act. So what do I mean by conservative restraintive court and activist progressive courts? Okay. So this is the best way to kind of put it in the sense of, again, you have the bend there. You try to be neutral, but again, your decisions that you've rendered in past decisions, okay, at the lower courts, maybe at the state court level, maybe a circuit court level, they're going to be indicative of how you view the law. Right? So again, when it comes to judicial activism versus judicial restraint, okay, the best governing judicial body comes into play when there's a balance between judicial activism and restraint. Okay, so again, that balance, that pendulum that oftentimes swings from left to right, okay, based on, again, that ideology of the Supreme Court justice in question. Right? So right now, the Supreme Court, after the death of Ruth Joan Bader Ginsburg, would be 6-3. Okay, so meaning 6 Supreme Court justices were put on by a conservative president, whereas 3 were put on by a progressive president. Okay, so again, that's where the bend of the court is now. Before that, it was 5-4. When Ruth Joan Bader Ginsburg, she was known as a progressive justice. So oftentimes, again, you get this idea behind this balance, okay, where this pendulum is trying to reach that balance. Okay? So what do I mean by judicial activism? Okay, this is more of a liberal view on the judicial branch. Okay, that means that the rulings on cases don't come directly from the Constitution, but from previous cases from the courts. Okay? So again, this is more of the activism based on not just plainly what the Constitution says, but being active as to what it could interpret. Okay, so the original writings of the Constitution, the only people who were enfranchised were, again, white males with property. Okay, so again, that's the original view of the Constitution. So an activist court justice would say, it's based on activism that's really changed the interpretation of the court, more encompassing based on, again, what it means for to be, again, granted life, liberty, and the pursuit of happiness or property. Again, different ways in which how activism at different times has taken on different themes, again, based on interpretation of the Constitution. Whereas judicial restraint, okay, you have more of a different view because it supports more concrete constitutionalists. Okay, the idea of specificity in the Constitution, not using it as an active springboard, but interpreting it literally. Okay, so again, it's more of an idea that should only make decisions based on the ideals of the Constitution. Okay, so again, more in line with restraint in terms of not springboarding or trying to make interpretations that aren't necessary. Okay, so again, utilizing more of a restraint based on what needs to be interpreted in a progressive way. So they're more restraintive in the sense of how they allow certain acts, certain laws to be interpreted moving forward. All right. So sources of American law. So where does our law come from? Okay. So just like the Constitution itself, the colonists themselves, it came from Great Britain. Okay. So when it comes to common law, this is judge-made law that originated in England. Okay. This is shaped according to prevailing custom. Okay? So in the sense that our generation, just as much as the older generation, the boomer generation, that again, one day the younger generation will take over. Okay, so based on prevailing custom, the interpretation of law may change. It may stay the same. It all depends. Okay, so let's say, for instance, Plessy versus Ferguson. Okay, during the Jim Crow era, was considered common law. It was prevailing custom at the time for discriminatory action to exist based on separate but equal. Whereas in 1954, that common law changed. That prevailing custom said separate is not equal. Okay, so again, this idea that it's shaped according to prevailing custom. Every generation gets to apply similar situations and gradually become common in the nation. So precedent is a big term in the sense that it is specific to a ruling bearing on subsequent legal decisions. Okay, so similar cases when it comes to setting a precedence. I'm going to show you guys a flow chart in the next slide that specifically talks through what a precedent would be. Stereodesis, this is just a Latin term, just means to stand on cases. You're going to find a lot of origin in Latin as well when it comes to English tradition based in common law, based in how we here in America have, again, utilized those customs and traditions and made them our own. All right, so case law. Okay, so whenever I've used case law, or if you've ever heard the term case law, this is based on interpretations. Okay, so as decisions are being made, case law is also being made. Okay, these are principles and doctrines, interpretation of the constitutional law, statutory law, and administrative law. Right. So what is the difference between civil law and common law? Okay, civil law is basically more of a it's a list of laws that exist in a society where judges are just simply finding the law and trying to apply the law. Okay, its origins are in Roman jurisprudence. Okay. In the sense that it's a code, it's detailed, all-encompassing set of rules and regulations. When it comes to judges, they're simply root applicators, like I said, of the law. Okay, they find the law and apply it. Okay, whereas in common law, what we practice, more origins in English tradition. Again, you think about judge-made law. Okay, judges are constantly making law. They're making decisions that are becoming common law within the interpretation of what certain circumstances, certain cases speak to. Okay. So again, it's essentially judge-made legal positivism, okay, in the sense that it's judge-made. You're not looking at rules and trying to apply them. You're actually making and interpreting the law as you make these decisions. Stereodesis is key in the sense, again, to stand on cases, how you stand on them. Again, not only indicative of, how the outlook of the judge is, but also the origins of what common law is. Okay, the idea of standing on precedents. When do you go against precedents? Okay, that's a big, big question that only the Supreme Court justices really can make a decision based. Like I said, when it came to Plessy versus Ferguson, okay, separate but equal. In 1954, all 9 judges went against precedents. Okay, they said separate was not equal. Okay, so again, when a court will take up the specifics of going against precedent. Okay, that's a big decision. Okay, again, based on, again, why the interpretation of the law would exist in that way. Okay, and it's very, very indicative when you have all 9 justices saying separate is not equal. Okay, and completely reversing course as to what precedents are stood for. All right. So what do I mean by precedent? Okay, so this is a little flow chart there. It's the legal principle or rule created by a court which guides judges in subsequent cases with, again, in that red, similar issues and facts. Okay, so again, that's going to stand for your precedent. It has to have those similarities in context. To serve as a precedent for a pending case, a prior decision must have a similar question of law and factual situation. Similar issues and facts come from, again, it's going to be standard of what the question of the law is and the factual situation surrounding that very case. Okay, so again, when you're talking about that, it's sometimes called authority. Okay, precedent is sometimes referred to as authority to make a decision. Okay, the precedent to make a decision. So you see that flow chart there. Again, those similar facts and issues of a past case can then serve as a precedent for the current case or future cases that will come about. All right. So what about when it comes to how a judge can render a decision. Okay, so when we're talking about the idea of jurisdiction, okay, not every judge can hear every case. Okay, there comes an authority that comes with jurisdiction. Okay, not all courts have the authority to decide all cases. Okay, it's delineated. You have superior court levels, you have appeals court levels, you have Supreme Court level. Okay, so again, all of these in the federal and state courts that exist, again, when you're talking about jurisdiction, it speaks to where a case arises and what its subject matter are two jurisdictional issues. Okay, so again, this speaks to, again, how you may have addressed federalism. Okay, the idea that, again, different states are going to have a different take on how they view minimum wage, how they view abortion, how they view immigration. All of these different circumstances that exist that, again, speak to how the jurisdiction of those local courts, those appellate courts are going to oftentimes render their decisions. And I'll speak to that in a couple slides here with the map of the appellate court level. Federal question. So federal question, a question that has to do with the U.S. Constitution, acts of Congress, or treaties. So I'll be going over it more in detail, specifically in the presidency chapter with regards to everything that went down this past week. The acquittal, the second acquittal of the impeachment of former President Trump. So again, I will specifically speak to that. But again, when you're talking about a federal question, that can be one in the sense that it has to do with the U.S. Constitution, acts of Congress, or treaties. Okay, so again, specific to that, you can see that as an example of one. Again, where interpretation of, I'll go over it in chapter 10, but high crimes and misdemeanors. Okay, what is that interpretation, what it means, and how it's rendered. All right, so diversity of citizenship. When you're talking about specifically being from a different state, you have two parties from a different state or from a different country. Okay? So it can also be a government or citizen of a foreign country that provides a basis for federal jurisdiction. Okay? So let's say if there could be a diversity of citizenship when litigation takes place with regards to COVID-19. There's probably at the world court level, like I said, litigation that's being ready to be placed on China, the blame on China, whether, again, that's going to, actually happen in the sense of rendering any judgments, financial and otherwise, it'll be yet to be seen. Okay? But again, diversity of citizenship would give, again, that jurisdiction, that idea behind that a suit involves a U.S. citizen and a government or a citizen of a foreign country. So, again, the nature of suing the People's Republic of China, whether, again, it's going to specifically happen in the sense of judgment being rendered, where monetary and financial compensation is, that's going to be far off. A lot of times, whether the world court is going to even take up the case or, again, getting all the specifics that, because we're still in the middle of it. We're still really in the thick of it. So, again, everything else that's going to come with, the blame game, there's going to be finger pointing both in different directions. So, that's going to be interesting. It'll be interesting to see, where the specifics are with regards to who the blame is, placed on. Was it in Wuhan? Was it in a virology lab? I don't know. But again, an investigation needs to take place. It just does. Regardless of situations, all of that stuff is so, important to not only understanding the virus, but again, making sure that it doesn't happen again. And we're not having biological warfare, because again, that's basically what it seems like, is biological warfare. So again, when you're looking at circumstance, when you're looking at diversity of citizenship, that could be a question here after, COVID-19 has seen its last days. All right. So specifically when it comes to the idea of judiciable controversy, that's when something is real and substantial, okay, as opposed to hypothetical or academic. Okay? Meaning, let's say a situation that is real, judiciable controversy. So the Capitol riot did happen. Okay, January 6th, it happened. Who's to blame? I don't know. But again, when it comes to the situation that judiciable controversy is, this is when something is real and substantial. So an example would be the Capitol riot. Okay, it's not hypothetical, not a what if. It actually happened. Okay, so again, whether rendered decision based on, again, the merits of subsequent civil cases that'll go on, because again, even though the president was acquitted, he can still stand civil damages, civil trials again that are going to come his direction in different ways. So again, that's why they're Congress right now is talking about an inquiry, setting up a commission that would do an investigation, the whole 9 yards behind the communications, the technology that was being utilized, all that ping technology that I talked about earlier in chapter 4. When it comes to what the government is allowed to gather on everyone, like I said, it's with your phone you can go back years. Okay, if you've had it for years, it can go back that long. So again, the idea behind putting all the pieces together, whether that commission is going to happen or not, we shall see. All right. So when you are ready to go to trial, okay, either in a criminal court or a civil court, you are ready to litigate. Okay, so that means to engage in a legal proceeding or seek relief in a court of law to carry on a lawsuit. Okay, so again, whether that be in the criminal court system or the civil court system, where again you may have been wronged in some sort of way, again, litigation means to engage in a legal proceeding. Another Latin term, just like stare decisis, this is amicus curiae. This is Latin for friend of the court. So again, the idea behind a lot of Latin influences that go into dialogue of why the court, habeas corpus, all of these different ideas behind what the court is understood. So your brief is your argument. Okay, this is the way you want the judge and or the jury to see the case in your perspective. Okay, this is usually written by your lawyer, utilizing precedent. Okay, so different cases that have happened and finding a way to piecemeal it to basically buttress your case, make it as strong as it can be, based on, again, the legal argument that's supporting that desired outcome. Okay, so again, your brief, it's filed by a third party who's not directly involved in litigation, but who has an interest in the outcome of the case. Okay, meaning oftentimes your representative, your lawyer, who has that interest in that case, because sometimes, again, not only are they paid sometimes to litigate, but the outcomes of the case, based on, again, taking cases on contingency. If they win, then they'll get the money. But again, all of these ideas that come with writing a brief, preparing what that desired outcome would be. Class action suit. Okay, so whenever you hear those long-winded commercials from, let's pick on, I don't know, the Goldwater Law Firm. If you are experiencing asbestos poisoning, please call. All of these people are basically soliciting people that are in a similar situation, okay, with regards to asbestos poisoning, paraquat, um, let's say all of this, when it comes to Parkinson's disease, all of these ailments that come from, sometimes toxins, sometimes specific chemicals, where again, people that are in a class action lawsuit, they're filed by an individual seeking damages for, quote, all persons similarly situated. Okay, so again, when all of these individuals that come before, a class action lawsuit, so let's say some of you went over the opioid addiction, which is awesome in the sense of, again, where different states are looking to combat the rise in use, the rise in overdoses, the availability of Narcan, okay, as a way to, knock people out of the overdose state. Okay. So again, when it comes to class action, you saw that with the pharmaceutical companies. Let's say when it comes to OxyContin, you saw the ability of a $1 billion company, the Purdue family, Purdue Pharmaceuticals. They make a lot of money. Okay. Incest, subsess, they make fentanyl. They make a lot of money. They are legal drug dealers. They are basically, I see them as, they may not be killing people with AK-47s, but, they're doing it in a suit and tie. A lot of them, they know that they're, what they're selling their individuals, their patients, how they're oftentimes pushing them on doctors saying, if you get this many prescriptions, from your patients, we'll give you a bonus at the end of the year. So that's an incentive. A lot of times that's why you'll get these doctors that push these, they're drug dealers too. I mean, your local homeboy down the street or something like that. No, these, doctors, they're getting incentivized too, oftentimes to write these prescriptions. And they'll get a bonus, let's say, to go to an exotic location at the end of the year for vacation, or to meet and greet with other medical doctors at some conference that, again, is all bought and paid for. So again, when you're talking about why these situations happen, oftentimes, when it comes to a class action lawsuit, it's a little slap on the wrist. Okay, these companies are multi-billion-dollar companies, and oftentimes they're shelling out a couple million here, a couple million there. That's a drop in the bucket. I mean, that's oftentimes what they refer to as the price of doing business. Okay, because again, they're just expected to pay that, as a tax every once in a while. Yeah. Let's see, Chloe. So court is scary. 0 out of 10 recommend it. I'm having to go, but I'm a witness to a case. Awesome. When it comes to my advice, because I have served on a jury, both in a criminal and in a civil case, just as pointed and as frank and as honest as you can be that. Okay, because again, they sniff out bullshit for a living. They're judges. So again, when it comes to being cordial, being respectful, they can, they know you're going to be nervous. Again, they can understand that and respect that. But again, just being as straightforward and honest as one can be, because again, when you get, given a summons to go to court, basically you are served process and saying, you've been served, you have to go to court. Again, you have to go to court, or you'll have a summons for your arrest. So again, that's
actually what they tried to do, because I had to go to court today. It's over a shooting that happened at my work, and the dude that there and the other side did, and they were like, "Are you sure she's not here?" He was like, "Yeah, she's not there. I want a warrant out for her arrest." And I'm literally sitting outside of the courtroom. It's not fun.
No, that I completely, that's where that 0 out of 10 recommend. Yeah, no. And just in the sense of, again, Claude, I mean, as much as you want to respect, don't ever fear, because again, that's the idea of not asserting yourself. You're there. You're living and breathing color. So they should not issue you a warrant for your arrest at all. So again, just know and maintain yourself. And again, being as straightforward as you are, nobody wants to be there, especially when they're called into a witness to such a severe case when it comes to, again, a shooting at your work. So again, all of these things just need to kind of, process when you're there. Again, the lawyer from the other side that didn't call you is going to try to make you look bad, or all these different word twisting mind games that they play sometimes, where again, you got to be cognizant of, because they try to make you slip up on your words. They ask you the same question 5 different freaking ways. That's just the nature of what they do.
That's what the district attorney was doing, because they're trying to basically, I got subpoenaed in for the dude the dude that shot at the store, and he's trying to say that he wasn't there. So what the district attorney was telling me was they were trying to use it as like an intimidation tactic, because they're like, oh, your witness is not here, your story is out of here, because they're trying to get the attempted murder charge thrown out. So
okay.
Yeah, and then I was there like all day today, and I walked in the courtroom for like 2 minutes, and then they were like, you know what, we're going to go do a continuum. So now it's an ongoing court case, and I have to go back and forth a bunch, which isn't fun.
Oh, no. And they'll have to serve you with process every single time. So again,
so I was subpoenaed in the first time, and then they said, like, you're no longer under a subpoena, but you're supposed to be here at this date at this time. And I was like, okay.
And don't be surprised, Chloe, if that date changes, because like you said, it's a continuance, and one of those things where, especially now, let's say a lawyer will get sick, the defense lawyer will get sick, something will happen, the judge will get sick, something will happen that, again, a lot of these cases don't get adjudicated for years, especially if it's a violent case. When it comes to continuance after continuance, all those different elements that have to go in. I empathize with you, Chloe, because that isn't fun. It's one of those situations where, again, when you're caught in the crosshairs of the law and you're not even the culprit, it sucks, because again, you have to, come to the understanding that, again, the law is expecting your lens and a perspective. And they're thinking it's critical enough to bring some light or shed light to that case. So again, my advice to you, just being as frank as you can be, because again, you are there in the sense of what you saw, and just, being as honest as you can be. Yeah, it is your civil duty. Yeah, that's kind of how I had to rationalize the jury of a criminal and civil case. It wasn't fun. I was a juror on a rape case. It involved a 15 and a 17-year-old. It was definitely not my finer 3 weeks that we had to sit there. And hear the agony, the stories, the tears. I mean, it was just, it was agonizing to the point where it's just, you don't know what to expect when you're hearing these kinds of cases. But again, you're just doing your civil duty, and it's as heart wrenching and as gut wrenching as it is, and as angry as you get at the culprit, the suspect. You have to rationalize and say, okay, I'm called in to be a juror because, again, getting that piece of society where this person, obviously deserves a fair trial. But again, when the swing of Lady Justice rules against that individual because the evidence is so insurmountable, again, that's where that situation happens, where you're, okay, this person deserves to be in prison for as long as they can give, the sentence based on, again, what the rape was, the underage nature of the women. It was one of those things where, again, it was a good experience in the sense of understanding what the law entails. But again, the details of the case were just so, just devastating, just to even hear and hearing these two poor girls, having to retell the story. Again, that's where you come to the lens and say, that's why it's so hard for, to get a conviction off of a rape case, because women are just not, they don't have the ability to be strong enough to be in a court telling 12 other strangers and the judge, everything that happened to them, replaying that in their mind. That's why a lot of, rapists or different sexual assaults don't get, they just don't get prosecuted, because again, it takes a lot. It takes a lot for a girl to come forward, especially an underage girl. Okay. So that was one of those situations where it's, again, brings up those anxiety-ridden times where you're just like, oh man, okay. And it brings light to, your family, in the sense that, again, knowing that I have family members that were that age, and doing my part to, again, make sure that criminals like this, do their time. And again, the execution of that by a jury by way of judge. Right. The other one was a civil case. It had to do with the overlay of the road, specifically in the mountains. Okay, so it was specifically a strip of road that needed to be in the mountains. So when it comes to coming by way of concrete, laying the road, it comes with a certain mixture when it comes to dirt, oil, and rock. Okay. And in the mountains, it has to be even more particular because it freezes. Okay. So in this civil case, this company that basically got the mixture from this other company basically was making the case that they gave them the wrong overlay, and it cost them a lot of money, because then they were sued by the county and so forth. So this mixture, again, you have to be particular in the mountains with certain mixtures, because, like I said, the roads will freeze, black ice will happen. So again, you have to have a certain mixture. So we were shown different, mixtures, different ideas behind what that means. And we, found out that, again, the plaintiff in the case that said, hey, this wasn't, this is, the responsibility is on the overlay company, the ones that produced or that gave us the rap, So again, they were the ones that we found that were responsible for that. Okay, so again, you get different cases. You don't know what you're going to get based on, again, when you serve as a juror. Again, don't lie to the judge. That's my biggest beef. If you're called in for jury duty, nobody wants to be there, and nobody wants to be called and stay there for 2 weeks. But again, don't lie to get out of it, because again, they fish out bullshit for a living. So again, be prepared for a tongue lashing if you do, because they can always say, hey, what is your extenuating circumstance? What does that entail? Can we call your boss? Can we call this? I mean, they will get down and dirty. Don't get me wrong. I'm like, they will. And I've seen it. So again, being as straightforward as you can. All right. So when it comes to, went a little quick there. When it comes to the bifurcated process, okay, this only happens in death penalty cases. So when murder happens, this is the only time you'll have the bifurcated process, okay? Meaning a separate trial for guilt or innocence. Okay, so that's your first trial. Either the person's found guilty or innocent. And then in the guilty phase, what is the penalty going to be? Is it going to be life in prison, or is it going to be the death penalty? Okay, so again, depending on the severity of the case, the bifurcated process is the initial guilt or innocence. If you're guilty, you go on to the penalty phase. Are you going to serve life in prison, or are you going to be given the death penalty? Okay. Again, that's only for the bifurcated process, death penalty cases. All right, so where to litigate? So as I mentioned earlier, depending on where a case is, oftentimes it's reflective of that conservative or progressive idea behind where that case is going to kind of go towards. Okay, what do I mean by that? So the Ninth Circuit Court, as it has right here, the Ninth Circuit Court is known as the most progressive. Okay, it's the Western Seaboard. So again, when you're talking about the Ninth Circuit, it's known as the most progressive. Okay. The Fifth Circuit, okay, right there in Texas, Louisiana, Mississippi, that is known as the most conservative, along with the 11th. But again, when you're talking about where a case happens, okay, so let's say a case involving a pro-life or pro-choice, pro-Second Amendment, pro-gun control, depending on where the case happens, oftentimes is reflective of what type of court is going to eventually hear your case. Okay, so again, when you're talking about what this federal question is, this is specific to what I mean. Okay, so you have that breakdown of where these district courts are that again are reflective of where, let's say, if you're put in a situation, where is the conservative or progressive bend going to be? Is it going to be favorable to your case, or is it going to be unfavorable to your case? All right. So when you're talking about trial courts, this is the first level of court. This is where most cases begin and testimony is taken. Okay. So again, this is taken at the criminal court, the civil court. So trial court again is where judge is going to be answering to lawyers that are specifically asking that certain evidence be utilized or suppressed, and all of those decisions are then rendered by that judge. Okay, again, based on again what the circumstances of the case are, and so forth. Okay. So general jurisdiction and limited jurisdiction. This has to do specifically with the extent of a court's authority to hear a case. Okay, so general jurisdiction is very flexible. Okay, when a general jurisdiction exists, a court of general jurisdiction normally can hear a broad range of cases. Okay, so it's not specific to just certain specific cases like limited jurisdiction is, where it's only types of tax claims and bankruptcy petitions. Okay, so again, when you're talking about general and limited, when a court's authority is limited or if it's flexible, exists in those types of jurisdictions. All right. So what happens if you did not get the justice that you wanted? You can appeal the case. Okay. So if the judge at the trial court said, you are found guilty, or if they say, your lawsuit cannot move forward, you can appeal the case. Okay. So what do I mean by appeal the case? The appellate court has the jurisdiction to review cases and issues that were originally tried in lower courts. Okay. So again, the ability of an appellate court can hear or review these cases from these lower courts to give an extra eye specifically to. If you are convicted of murder, you are automatically sent to the appellate court level. You don't have a choice in that way. So again, the appellate court, specifically speaks to appealing that decision. So what about federal courts and the war on terror? Okay, so if you've ever heard the term secret courts, okay, secret courts. So shit, what does that mean? Okay, so when you're talking about secret courts, okay, it is particular to FISA courts. Okay, the FISA court was set up after the Patriot Act. Okay, so after 9/11, the USA Patriot Act was signed. This allowed a 3-judge tribunal, okay, chosen by the Chief Justice. Okay, so John Roberts got to choose when he, is being the current Chief Justice. He gets to choose who these 3 judges are. Okay, they are hearing the warrants concerning terror, all the stuff that is done in secret, because a lot of that information is very sensitive. It's classified. Okay, so whenever you hear that term secret court, okay, that's what it's referring to. It's referring to the Foreign Intelligence and Services Act. Okay, so FISA specifically created through, again, when you had the war on terrorism after 9/11, this set up that secret court to hear these warrants, the information that was going on with regards to terror cells in different countries and so forth, and domestic. Also, referring to alien combatants, enemy combatants, and deeming them as so. Okay, so there is a sticky situation with that, in the sense that the FISA courts have allowed a situation to exist that could be deemed questionable. Okay, so what do I mean by that? So there's a situation a few years ago, an individual by the name of Anwar al-Awlaki. Okay, Anwar al-Awlaki, by all intents and purposes, very misguided. He was born in the United States. Okay, intelligent guy. Okay, went and got his bachelor's degree at Arizona, I believe, Arizona State or Arizona. Was in the middle of his graduate degree back east, and he radicalized himself. Okay, became radicalized, became an Oman, started preaching hate, started preaching all those things. So he became public enemy number one. Okay, so he was born here, but he fled to Yemen. So what happened was the FISA court allowed the drone bombing of Mr. Anwar al-Awlaki. Okay, and again, I'm not justifying Mr. Anwar al-Awlaki. He was a bad guy. He himself didn't specifically kill anybody. But again, when you're talking about preaching hate, preaching words that can eventually get soldiers killed, it becomes a sticky situation, in the sense that, again, he's still an American citizen. He was still born here in the States, and he went to school here. He got his undergraduate degree, and he radicalized himself. So again, when the government has the ability to send a drone bomb to another country to kill one of its own citizens, even though that citizen is not the best citizen, I'm not going to deny that. But again, that creates a sticky situation for the rest of us. Okay, what is justified, basis for what were the ability for us to do? So again, different ways in which the FISA courts have, specifically speaking to how and what type of cases they hear when it comes to, again, fighting the war on terrorism, sending out drone bombs to, again, potential targets that, again, could do us harm. All right. So if you did not get your sense of justice at the appellate court level, so you were unsuccessful at the trial court level, you were unsuccessful at the appellate court level, you got one more shot. Okay, one more shot, and that is if you are extremely lucky. Okay, so what do I mean by that? So oftentimes when it comes to hearing a case that the Supreme Court actually wants to hear, it has to do with uniqueness. Oftentimes the idea of setting some sort of standard for future cases. And oftentimes if it doesn't have that angle, the Supreme Court will just not even hear it. They'll just, you can appeal for years or, to be heard by the Supreme Court, and they can deny you every time. But again, when you are heard by the Supreme Court, it is referred to as a writ of certiorari. Okay, so this is specific to when the Supreme Court is sending up a case for review, saying, hey, lower court, send up all the information because we want to hear this case. Okay, we feel this case is going to make some sort of unique understanding, interpretation of what the law is. So, as I said, there are 9 justices. So, in order for a case to be heard, it's referred to as a rule of 4. Okay, so, as long as 4 of those 9 justices say, hey, we want to hear the case, it's going to be heard by the entire court. Okay? So, oral arguments. So, this is where your lawyer is, in front of the court arguing your case, either at a criminal proceeding or a civil proceeding. But again, giving oral arguments is basically your brief. Okay, your brief, but done in, before the court. Basically explaining why, you as the individual that is being represented has to be heard in the sense of the law being understood in the way in which your brief states. Okay, so. Each attorney presents reasons to the court why the court should rule in his or her favor. Oftentimes, though, even Supreme Court justices will admit this. They already come in, knowing what they're going to vote. Okay, so it's kind of a formality in the sense that oftentimes they'll hear oral arguments, but Supreme Court justices, by their own admission, have said they come in already knowing what they're going to vote. Okay, so oral arguments are just more of oftentimes just basically noise, because these justices will come in with having read all the circumstances to the case, and the song and dance of the lawyer is really just kind of an act of sorts. So once that's done, all 9 justices get to their clerks. Their clerks are those individuals that help them, write their opinions. Okay, so oftentimes these justices are old. Okay, there's no bones about it. They are old, and they're older people. So again, they need these clerks to really help them write their opinions, their understandings of what they want the law to be, again, based on their interpretation. But again, you lose your sharpness when you start getting older. So, oftentimes law clerks are, doing a bulk of the work for, the Supreme Court justices. So once this opinion is rendered, opinion sets forth the applicable law and details the reasoning on which the ruling is based. Okay, so it'll say, in the sense of what type of decisions can be made, they can choose to affirm the decision. Okay, affirming is that basically everything was done properly at the trial court level. It was done properly at the appellate court level. So when the Supreme Court affirms a case, this is declaring that a court ruling is valid and must stand. Okay. If the Supreme Court chooses to reverse the decision, okay, that's to annul or make void a court ruling. So this would be on the account of some error or irregularity. Sometimes a witness will recant, or maybe a new witness will be interviewed. And again, this will, sometimes cause a mistrial or a reversal in the decision that's now rendered by the Supreme Court. Okay, so again, all these nuances to the cases that oftentimes are reflective on new details that sometimes come about. Or they can choose to remand the case, okay, meaning the Supreme Court can choose to send it back to the court that originally heard it. Okay, so like we said, the trial court level, if the Supreme Court remanded, it would go back to the trial court level. Okay, so they would get another case based on, again, this error, irregularity. Maybe it needs to get heard again to get another idea of what justice is. Okay? All right. So what types of decisions? Unanimous decisions. Okay, so that's when all 9 Supreme Court justices agree to the merits of a case. Okay, so they figure the determination on which all judges agree. So like I said, Brown versus Board of Education was a 9-0 decision. That is a unanimous one. Okay. Majority opinion. So this is when 8 to 5 justices reflect the views of the majority of the judges. Okay, so that's that threshold when it would be considered a majority opinion. Concurring opinion, on the other hand, this is when a justice will support the decision of the majority of the court, but for different reasons. Okay, so basically a different legal rationale. So it'll eventually come to the majority of the court's decision, but just based on a different legal precedent that's being discussed in the merits of the case. Okay? That would be considered a concurring opinion. All right. So what would be a dissenting opinion? So like I said, Ruth Joan Bader Ginsburg, my favorite justice, RIP, RBG. But when it comes to what a dissenting opinion is, this is a separate opinion in which a judge dissents from, disagrees with the conclusion reached by the majority of the court and expounds on his or her own views. Okay, so Ruth Joan Bader Ginsburg, known very much as a dissenter based on, again, the circumstance of enfranchising women, people of color. She was very progressive in her views in that way. She was quoted as saying, if I could choose an amendment to add to the Constitution, it would be the Equal Rights Amendment. And so like I said, last chapter, since 1923, women have tried to get an Equal Rights Amendment passed. But like I said, there's just not enough women in power to make that possible. And again, the dying wish of Ruth Joan Bader Ginsburg, being able to have this Equal Rights Amendment. So never underestimate the power of a girl with a book. I never do, because again, my fiance, she's very smart, smarter than I am, I think. So again, I never underestimate a woman, or I get the backhand for sometimes the rightful reasons. And dissent, notorious RBG. So like I said, known for her sassiness, known for her being a spitfire. She's going to be missed. All right. So what about the selection of federal judges? Okay. So again, how are federal court judges chosen? When it comes to nominations at the federal court level, senatorial courtesy allows the senator from that state to veto a judicial appointment in his or her state. So let's say, for instance, in the state of California, okay, our senators being Dianne Feinstein, who I can't believe is running for another frickin' term. She's like 88 frickin' years old, and she's running for another 6-year term. Blows my mind. She'll be 94 if she wins this election by the time her term is over. Okay. Some people got to know when, it's past their time to get off, just sometimes, people can't let go of power. And that's a shame because, again, when it comes to new blood, especially here in California, there are so many, more energized politicians that could, completely speak to our state. And not dissing her, but again, you got to know when to let go. But again, that would allow Senator Feinstein to veto a judicial appointment in the state of California. So whenever a federal judgeship comes into play, senatorial courtesy says that senator from that state, one of the two, can veto. Okay, so Alex Padilla was just given the role by Governor Newsom to be the second senator replacing Kamala Harris because, again, she's taking the reins of vice president. So, again, different ways senatorial courtesy exists. Right? So, yeah, you got to hear my rant about, I'm going to be ripping on a lot of people throughout the course. Not that I won't, but again, when it comes to both sides, I'm going to be just as when it comes to the congressional chapter, just as bad with Mitch McConnell, just as bad with Lindsey Graham, all these individuals that, again, I think you start detaching yourself from the common people when you've been in power for so long. And again, I'll touch on those aspects throughout the course. But again, when you're talking about, having a generation that wants to participate, I know, you as a younger generation, me as a millennial, all those different elements that speak to, again, wanting to get involved. It's hard when people are serving until their 80s and 90s, where again, there's nothing wrong with getting older. But again, you got to know when to let go of power. You have to know. All right. So again, senatorial courtesy expects that no candidate be appointed to an official position without prior approval from the senators. Okay. And senators specifically within that state. Okay. All right. So again, touching on the policies of activism and restraint, kind of what we went over right at the beginning of class. Again, right now, you have more of a judicial restraint, based on that 6-3 breakdown. 6, again, being appointed under conservative presidents, where 3 are under progressive presidents. So again, that's where that bend is right now. But again, judicial activism is where the judiciary is taking more of an active role to check the powers of the activities of the governmental bodies when those bodies exceed their authority. Okay, so judicial activism is taking, again, that springboard, that active role, checking the other two branches, the executive and legislative branches, when they are, possibly exceeding their authority. Okay? Where judicial restraint is allowing a lot of those decisions to be made without intervening. Okay? So judicial restraint is a doctrine holding that the courts should defer to the decisions made by the elected representatives of the people in the legislative and executive branches. Okay? So again, more of a deferring, the idea of it should be left to the other two branches to do amongst themselves without us taking an active role. Okay? So again, judicial restraint is saying we should be more passive in the sense that those decisions to legislative and executive branches should be made on their own end. Judicial implementation. Okay, this is the way in which court decisions are translated into action. This is a lot harder than it seems. Okay, things can be really, really rosy, or really, very good on paper. But when it comes to actually implementing the standard by which the law is saying, it's a lot harder. Okay, so like I said, last chapter, the civil rights movement. Okay, so Brown versus Board of Education by itself didn't do anything. Okay, it didn't do anything at all. It took the civil rights movement with the Civil Rights Act, the Voting Rights Act, to actually give teeth to not only the Civil War amendments, but what Brown versus Board of Education was doing. Okay, so again, all these elements that go behind judicial implementation. Jim Crow had to be thwarted, which was, again, it was hard. You had, sit-ins, you had marches, all of these different things where, again, people were getting arrested. All of these different things that were happening that, again, had to happen in order for the civil rights movement to be successful in any way. So again, implementation is saying, the way in which it's translated into action. And again, like I said, with the civil rights movement, the decision was made in 1954, Brown versus Board of Education. The civil rights movement wasn't, the Civil Rights Act wasn't until 1964. You see a whole 10 years later where, again, translating that implementation into action, by way of, again, acts, bylaws, all of these different things that were against discrimination of people of color. Right. So political question, this is specific to the idea that more of a judicial restraint in the sense that it's specific that the court believes should be decided by the executive or legislative branch or both. Okay, so again, taking that restraintive idea of passivity and kind of looking to implement it in that direction. All right. So your quick right for this week. Okay. So what does it entail? Okay. So what am I posing as a question? Okay. So this is only one question, but when it comes to putting some background as to what this is, you can, be specific to, again, bringing in elements of the PowerPoint, how oftentimes, again, you have this activist and restraintive court that exist in a certain way. Okay, so that'll be the elements you kind of want to put in. But what is my question for this week? Okay, should state judges be elected or should they be appointed? Okay, so what do I mean by that? Okay, so when a state judge is elected, okay, there are pros and cons to that. Okay, so when I say elected, okay, that means that a judge is running every 4 years, okay, to retain that seat. Okay, and I say there are pros and cons to that because the pro is, if these judges are not, their decisions are not the will of the people, we get them the hell out of there. We vote them out and they're gone. Okay, so that's helping retain that idea in the sense that, are we going to elect people or appoint people for life? Okay, so appointment for life is different in the sense that once you go through the ringer once, okay, you're on there forever. Okay, so again, when it comes to, let's say, the Supreme Court, the state Supreme Court, federal, when it comes to the United States Supreme Court, all of those are, again, lifetime appointments. Okay, so the pro there, in the sense that if they are elected every 4 years, is that, you get a shot at them, but every 4 years, okay, that judge then has to ask for more money. Okay, more money from corporations, more money from local businesses, more money from Joe Schmo. Okay, so this is then opening that judge up for malfeasance. Okay, if a judge is having to worry about getting donations, okay, political donations to their campaign, you are opening that judge up to now being manipulated by way of business interests. Okay, they'll say, hey, Judge so-and-so, okay, we're going to give to your campaign. But, in so many words, they're going to say, hey, if we call you in the middle of the night, make sure you answer. Okay. And they're not going to say it in that way. But again, when you look at what you are opening a judge up to, if you are having them run every 4 years, right? So don't think that it doesn't happen either. There's a lot of judges that have gotten caught and gotten in trouble for helping out family members of people that have donated to their political campaigns. Okay, so again, this is actually a local one. Judge Petrocelli got in trouble for doing just that. So again, when you're talking about circumstance, again, there's a pro and con to that. Okay, if you are electing judges, us as John Q. Public, we're gonna get a say. We're gonna say yes or no to that judge. But again, you're opening them up to have to get these donations, to have their signs, to have their big banquets, to have their cheesy commercials, all the whole 9 yards. Okay, so again, all of that takes money. Okay, when you run elections. So again, that's the kicker there. Okay, but again, on the flip side, if you are shielding that judge, you were saying, you know what, we are going to shield them with a lifetime appointment. Once they go through the ringer, then they can serve for life. Okay. However, the con to that is now, once this person is on for life, if their decisions aren't reflective of the public, they can tell you to piss off. They don't care. They're on there for life. Okay, so again, there's a pro and con to having both state elected judges or appointed judges, because again, you're opening yourself up. Okay, so again, if you're having to run every 4 years, okay, like I said, it's a good thing in the sense that, yeah, your judges are now, having to make decisions with the public in mind. But again, like I said, every 4 years, they're having to get donations. They're having to field business calls for political donations, which again can cause a shitty situation, which again, we'll be going over in the interest groups chapter, which goes into more specifics as to what that is. Okay? But again, there is a pro and con. So looking into what that is, what would you see as a better idea? Or maybe possibly what you feel about that very question. And again, there's no right or wrong answer. It's more for you to explain, the context to the question. Well, maybe incorporating, like I said, judicial activism, judicial restraint, which again are big topics in this chapter. Okay? So again, how you would gauge answering the question, well, again, incorporating these themes, such as, again, judicial activism, judicial restraint, that, again, speak to, making, incorporating themes in your paper to make it longer, to hit that, closer to 2 pages, again, writing as much as you can to, again, reach that threshold. Okay? All right. Let me see if there was any questions. Not only on chat. Are there any questions, comments, concerns, issues, anything? How many pages? Same as any other quick write, closer to 2 pages. You want to get it, as close to 2 pages as possible. Again, not too big of a heading, so again, limit the heading and just put as much writing dialogue as you can. Make those connections. You're not just, limited to just putting judicial activism and judicial restraint. You can throw in other elements of, again, common law, why our law is seen in a certain way, why it's originated in England, okay, why that colonial experience still has a lot of rooted in the way in which we interpret our laws, the source of our American law. But good question, Diego. Good question. Any other questions, comments, concerns, issues that I can speak to at this time? No? Really? Oh, man, that's crazy. All right. So, again, I have a couple of Zoom meetings with a couple of students this week. But again, if you ever have any time or need questioning in regards to how your grade is, why it's specific to, again, maybe you didn't turn in an assignment, again, all of those different elements, reach out to me. I will definitely get back to you as soon as I can to answer any questions as soon as I can. All right. But if I don't have any, have a great rest of the week. I will see everyone next week. Possibly check out some of those videos that I posted, but not going to pull your arm about it. Have a great one. Peace.